What is up, guys? Welcome to Murray's Annie, and today we are going even further, even deeper down the SSSniperwolf lawsuit rabbit hole. Now, if you don't know who SSSniperwolf is, she's a content creator with over 33 million subscribers, and she has come under a lot of scrutiny lately for things ranging all the way from doxing fellow YouTuber jacksfilms, all the way to low-effort reaction content, and even having all of her videos scripted by her husband. Although now it appears that lawsuit is taking an even more drastic turn for the worst, SSSniperwolf's former husband, Evan Young Sausage, is actually a 50% owner of the channel. Now, this is causing a lot of problems which may lead to SSSniperwolf either having to forfeit her name or subsequently have her channel taken down or terminated, and we might have to see SSSniperwolf start afresh on a whole new set of channels. Now, imagine you just started a business with your closest friend. Let's call him Sausage for short. And you and Sausage have known each other for so long, you would even consider them family. You both decide to enter into a business venture together and split it 50-50. It becomes very successful. But then, people come around offering brand deals, offering cheap flights, offering free meals at fancy places, and even putting a bit more extra cash in your partner's pocket. Well, how would that make you feel? Would you accept it, or would you take them all the way to court? Well, imagine no longer, because that's what we're going to go into today. We're going to analyse the nitty and the gritty. Bonnie and Clyde. Yo guys, if you're enjoying this video, please be sure to like, comment and subscribe. Thank you so much for all the support recently. It really does mean the world. Let's get right back into the video, shall we? Okay, so if you're not updated on the lawsuit situation, basically we have this legal battle going on between SSSniperwolf and her former husband, and it just keeps escalating. And these things usually don't end for a good year, 2 years or so we can expect a lot more where this came from. So previously on our lawsuit saga, we analysed Celeste coming at Evan Young Sausage and basically accusing him of just being crazy and saying that she was pressured into signing this 50-50 agreement and that Evan Young Sausage manipulated her into doing all this, and that her going for brand deals actually helped Channel Red, which is the joint brand which Sniperwolf is under, that both Evan Young and SSSniperwolf own. Yeah, it's a bit to get your head over, but we'll get there. So to kick off Evan Young's reply to this, he basically states that there's been a breach of trust and SSSniperwolf is not acting in the best interest of Channel Red. Basically, Shalesh SSSniperwolf had certain responsibilities towards Channel Red, like being honest and acting within their best interests, and basically they're arguing that she hasn't done this at all. Young cites the fact that Shalesh has intentionally messed up brand deals, which hurt Channel Red and their project. So when they started Channel Red, they had some agreements and partnerships in place, which were supposed to be the thing that brought in money. They're basically saying that Celeste messed these up on purpose, causing harm to the SSSniperwolf brand. So I think they also respond to SSSniperwolf's accusation of derivative demand, where I think Sniperwolf was saying Young didn't verbally try to fix things with Sniperwolf before taking her to court. And usually it's expected that you talk to a person about the problem before you bothered the courts with, your business. But Sausage has basically responded by saying that there's no point in verbally communicating with Sniperwolf when that's all he does and there's only one owner in the company, which is Sniperwolf. And obviously he's brought these up to her verbally and there's no point doing it again because she'll just ignore it. So that's why Young has gone to the courts, or Sausage. Evan Young also expands in this legal document that Celeste, in her response to Evan Young, basically admitted that they are 50-50 owners and there's no majority owner within Channel Red. So sorting out this whole thing is quite difficult. So both Evan Young and Celeste were in charge of making very important decisions for Channel Red, and they were also part owners of the project all the way back from the beginning. So this means that they have a say in how it's run. And because there's a lack of majority control, i.e. someone owning 51% and someone owning 49%, there's no one fully in charge. Shalesh and Young both share all of the power. So adding even more evidence to the fact that if Young asked Shalesh to change something or fix something, it was more than likely never going to happen unless it did enter the court's doors. I think there's also a intentional interference claim within this whole lawsuit, and basically that just even further delves into Shalesh going into brand deals and ruining brand deals and all this kind of stuff at detriment to Channel Red, which has negatively affected the channel and Sausage. And this leads into Young's conversion claim, basically meaning that you're taking something from the business, i.e. from the SSSniperwolf channel red conglomeration, and you're stealing it and using it for yourself. So here an example of this might be where SSSniperwolf has basically bounced from her official channel and just started uploading on SSSniperwolf Espanol or on her other SSSniperwolf highlight channels or this kind of stuff, trying to siphon off money directly into her accounts rather than through the joint account in channel red. Like, imagine you're working on a group project and someone basically takes all the credit for it and benefits themselves instead of sharing with the team. And Young is basically explaining that SSSniperwolf has taken these opportunities and directly used them for herself instead of benefiting the channel red business. Now, we also get into an accounting claim that Evan Young Sausage is bringing up here, where it's looking at the financial books and making sure that everything's clear and checks out alright. Just like you check a bank statement and, you know, make sure everything's in order there for the tax man. They just want to check that Channel Red's financial records are all squeaky clean. And Sniperwolf hit back with this and said that this isn't a thing in Arizona. So she cites some Arizona type law things and says this isn't a thing, so you can't pull me up for this. And she cites some New York thing from some New York courts. But Young fires back and he believes that this accounting claim remains true. And what's even funnier is that Selesh is asking for legal fees to be paid from Evan Young, basically asking to cover her legal fees of like a $300 and something, which is hilarious because she makes so much money. But currently we haven't entered the stage where they have to share evidence to basically be analysed by the lawyers and all this kind of stuff. So we're kind of just in this ping pong sort of table tennis thing that's going on that might not end for a very long time, as per usual in these kind of family business debacles. Okay, so now let's start reading a bit of this legal document, shall we? If you haven't been caught up, this basically introduces the scene. Young and Selesh are husband and wife who are in the midst of a divorce proceedings in family court. More than a decade ago, Young and Selesh formed a business venture in which they created content for their YouTube channel known as SSSniperwolf. Both Young and Selesh played an important but distinct roles in their business venture. Young created the SSSniperwolf channel and the scripts for the content. Selesh was the face of SSSniperwolf, who reads the scripts while Young filmed her. These videos were posted online to the party's YouTube channel, and the parties formed Channel Red as the entity which their business venture operated. The business venture was highly lucrative. Unfortunately, as their marriage frayed, so did their business relationship. Selesh initially brought suit against Young in a different action, claiming that Young had restricted access to their YouTube channel, but acknowledges that she allowed the action to be dismissed. Plaintiffs thereafter filed this action against Selesh on August 12, 2023, asserting claims for the breach of fiduciary duty, breach of contract, breach of the implied covenant of good faith and fair dealing, tortious interference with contractual relationships and business expectancies, conversion, accounting, and on the appointment of a receiver for Channel Red. On October 10, 2023, Selesh filed her answer to Young's complaint and asserted counterclaims for the breach of fiduciary duty, declaratory relief, breach of contract, breach of the implied covenant of good faith and fair dealing, and dissolution of Channel Red. That's a mouthful, but basically here asserting that the claims filed against Young and the claims filed against Selesh, they're basically both trying to file claims for the same thing for each other, because I guess it is funny because it does mirror each other because they are 50-50 owners, so they're both firing equally the same thing. So here we have Young's response to the claims that he is vindictive and surreptitiously engaging in behaviour that is nonsensical, spiteful, and unhinged. So here, formerly SSSniperwolf basically tried to put those labels on Evan Young to basically make him look like this crazy, deranged person who's just trying to seize all the power that they can get for no reason other than to bring Sniperwolf down because he's jealous. Which is, you know, a really stupid card to play, because I don't know, if you're a judge, you know, you can kind of see almost who's got the head screwed on and who doesn't. Rule 12b6. Asserting the claims have not been sufficiently pled and therefore fail to state a claim. As shown below, these arguments are either wrong as a matter of law, require the court to evaluate the evidence, which the court cannot do at the pleading stage, or put plaintiffs to the task of providing their claims, which is a burden plaintiffs do not have at the pleading stage. For all these reasons, the motion should be denied in its entirety. Finally, plaintiffs note that the motion is filed with Vective, accusing Young of having acted vindictively, surreptitiously, engaging in behaviour that is nonsensical, spiteful, and unhinged, and accusing Young of gaslighting Selesh. These ad hominem attacks are particularly inappropriate in a motion to dismiss where Young's factual allegations must be taken as true, and the issue is simply whether the causes of action Selesh's challenges state a claim for relief. Who did what to whom plays no part in that determination at the pleading stage. So that's right, Young here is basically saying, why are you, alleging all these personal attacks at me when I filed, a proper complaint and I've, had a factual basis, and you've basically attacked me for ad hominem things, which is basically just pure conjecture and just a subjective opinion. It's kind of and there's no point, and there's no reason for it at this stage either, because they're both filing to see if it even goes beyond family court, I believe. I'm not a lawyer. Once the hyperbole and vitriol was stripped away, the sufficiency of Young's pleadings rises to the top. And I'd agree with that, to be honest. I'd agree. Once you take away all of what Sniperwolf was saying, you can find that in our previous video, it really just does seem like she's just replying for the sake of replying. Plaintiff's claims should be decided in this case, not by the family court, especially because the defendant has filed counterclaims in this case. Defendant's lead argument is that the non-derivative claims, that is to say, the individual claims asserted by Young, are best left to the family division in the case of dissolution proceedings. Apparently recognizing that the statute and cases cites are specific to the domestic relationships of concept of waste, defendant insists that plaintiff's breach of contract and breach of implied covenant claims are simply disguised as community waste claims. This is simply incorrect. Plaintiff's civil claims for breach of the Channel Red operating agreement and breach of the implied covenant of good faith and fair dealing implied onto the operating agreement are not based on the domestic relations concepts of waste, but rather on common law contract principles. In other words, the family court's function to determine the terms of the parties' divorce, including the division of community property, is very different from this court's function in the adjudication plaintiff's contract claims. Even if defendants' arguments that permitting this court to determine the plaintiff's claims would duplicate the family division's work were correct, and it's not, defendants waived that argument by filing counterclaims in this case. Basically, I think SSSniperwolf was trying to keep it in the family division, and Young saying that because it's about the company Channel Red, this goes beyond the family division, and the family division only deals in their divorce. And I think Sniperwolf was trying to say, it'll just duplicate the family division's work, so we need to waive this off. But the fact that SSSniperwolf has actually responded to Evan Young basically validifies Evan Young here in saying that, no, these should be in this court because she's actually responded, so that means there's more to go into here. I actually have a case, which we'll probably see go through. Specifically, at the time she filed her answer to plaintiff's complaint, defendant asserted counterclaims for breach of fiduciary duty, deculatory relief, breach of contract, breach of the implied covenant of good faith and fair dealing, and dissolution of Channel Red. These counterclaims are based on the same business dealings between Young and defendant that are the factual basis for the plaintiff's claims, by asserting counterclaims after filing the motion. Defendant has conceded that this court is the appropriate forum for adjusting the parties' claims against each other regarding their business dealings. In addition, defendant's filing of the counterclaims as a waiver of her right to dispute the jurisdiction of this court to hear the plaintiff's claims. Oh, that's a lot. That's a lot of stuff. By the way, I just want to give a massive shout out to Mad Katzer, by the way, for providing these documents and providing way more insight than I could. So if you want a proper breakdown of all of this, please click the description below and go to his one. We're just glancing over this. I'm just going to read it out in the voice that I do. But yeah, if you want a proper lawyer to look at that stuff, go down below. While defendant is correct that plaintiffs did not make a pre-litigation derivative demand, Arizona law does not require a demand where it would be futile. Selesh has admitted in her answer that she and Young jointly formed Channel Red. Both of them were listed as managers and members of the channel as of date of its formation, and both of them remain as managers and members of Channel Red today. Selesh and Young each own a 50% membership interest in Channel Red. Moreover, in her prior complaint, Selesh alleged that on February 8th, 2017, Selesh and Young organised Channel Red, even though they did not enter into an operating agreement. They were both appointed co-managers and each owns 50% of membership interest. So there we have it, again, in clear writing. 50-50. Thus, neither Selesh nor Young has majority control over Channel Red, which means even if Young had made a creative demand on Selesh for Channel Red to file the claims against her, Selesh certainly would have rejected or ignored the demand, thereby making it futile. It's true. It's true. I think I'm siding with Young on this one. I think that's true. I think she would have ignored it for sure. So here we have a response to Selesh basically cited that in Arizona law that there's nothing as a accountant claim or something like that. So here we have also something about an interference claim, which if you guys are lawyers, please let me know about what these things actually mean. You know, I'm just going to read the writing for you guys. Plaintiffs have sufficiently pled their international interference claim. Defendant argues that Young has failed to plead his international interference with contractual relations / business expectancies claim because he did not allege any breach. More specifically, defendant argues that her alleged interference did not cause the loss of any brand deals, but instead, as a result of Selesh's interference, they actually signed deals. This argument misreads the allegation of the international interference claim. I think we're going to get into what the international interference claim is. Selesh unilaterally conspired with Channel Red's brand manager Kevin Gold to seek and enter into business arrangements and or business deals with certain companies, including but not limited to G Fuel LLC, without disclosing the details of said arrangement to Young. Selesh retained all of the profits from these unilateral brand deals, including but not limited to those with G Fuel in separate bank accounts, but not limited to the certain account with the First Republic Bank account number, obviously blank, without distributing any portions of the profit to Young through Channel Red or otherwise. These factual allegations, which must be taken as true for purposes of deciding the claim motion, clearly suffice to satisfy the breach element of the international interference claim. I hope you got that. So I think international interference is where you would have SSSniperwolf go off and get these brand deals with these other brands and then get the money put back into her account instead of Channel Red. I think that's maybe what it means. Yes, and now, instead of an international interference claim, we have a conversion claim now. So, plaintiffs have sufficiently pled their conversion claim. Defendant makes two arguments against the plaintiff's conversion claim. The opportunities of Channel Red allegedly converted are not intangible rights of the kind of customary merged into a document. With respect to the conversion of money, plaintiffs has not alleged a specific fund capable of description, identification, or segregation. Both of these arguments cherry-pick plaintiffs' allegations and call for the court to evaluate whether the factual allegations of the complaint suffice to prove a conversion claim, which the court cannot do at the pleading stage. Dismissal is appropriate only if, as a matter of law, plaintiffs would not be entitled to relief under any interpretation of the facts susceptible of proof. I think they're saying here we can't get into the conversion claim because we're only at the pleading stage where he's just, pleaded to get his little thing, and now we've got someone almost just accusing him of certain things without actual evidence in the pleading stage, which I don't think the family court is suited to deal with at the moment. So we're now getting into the accounting claim. With no citation to authority, defendants assert that with exceptions she says are not applicable here, Arizona does not recognize the actions for an accounting, and that accounting is merely a remedy subsumed by the breach of contract claim alleged in count number 1. The court is surely aware that plaintiffs routinely plead a claim for an accounting in cases involving business disputes where bank accounts or joint assets are an issue. Those accounting claims are founded on ARS something, which prescribes a 4-year statute for claims by one partner against his co-partner for a settlement of the partnership account. I think Selesh was basically saying that this accounting claim, where it's you have to look at the books to make sure they're squeaky clean, didn't exist in Arizona, but then Young basically disagrees. So I think this is where the lines are getting blurred between, being husband and wife and being business partners, and you have this ball being played here where it's this is a family matter and not a business matter, and you have Young here basically proving that these claims are to do with Channel Red and not to do with their partnership. Yeah, so here we have Young's response to Selesh asking for some money to pay for her legal fees. Defendant's request for attorney's fees is premature. Defendant requests an award of her attorney fees pursuant to ARS 12341.01, motion P4 something something. However, a fee reward would be premature regardless of how the court rules on the motion, because the defendant does not seek dismissal of the plaintiff's claims for breach of contract or breach of fiduciary duty, or plaintiff's request for appointment of a receiver. Therefore, parts of this case will survive even if the court dismisses any or all of the individual's claims on which the defendant seeks relief. Accordingly, even if the motion is granted, there would be no basis for a finding that defendant is the prevailing party, as required for a 341 and 1 cent fee reward. In addition, there is no deviate from the standard practice of entertaining an application for award of attorney's fees only after the entire case has been resolved in the trial court. It seems here SSSniperwolf has completely jumped the gun. She's asking to be rewarded in her legal fees for basically responding to Young's claims, but they're in the pleading stage, and usually you ask for the money for your legal fees after you've won the case. So that hasn't happened yet. In fact, we've only just begun. But yeah, that concludes today's video. If you've enjoyed what you've seen today, please be sure to like, comment, and subscribe. I will see you in the next one. Peace.